my books came in today. Mind if I share? I'm a little geeked out on it, so I want to bore you guys with it. So just. Yeah, I ordered some books, and they came in today. What do you know? So now let's open up. So, Aique Arma has a website that you can order books from. And, you can get 2,000 seasons plus. The Beautiful Ones Aren't Born Yet. And all of his books, The Eloquent Peasant. But these are new. These ones here are new. It's Book of Ptahhotep. And look, he's put it in to Arabic, English, French, and 9 African languages.
Beautiful.
Akan, which is tree, Bambara, Hausa, Kikongo, Kiswahili. I'm not familiar with this one. Pular. Anybody know what that one is? Wolof, that's Senegal. Yoruba, one of the 3 languages, major languages in Nigeria, and then Zulu. So it has all of these. Hey, Kat and Dandiwe, how are you? Yeah, this is his publishing company, Per Ankh. So if you did a search on that. And then, so in the Hosea, it's described as the eloquent peasant. And, but here it just has the peasant, let's see, what's this? The peasant's tale. That's what this is, the peasant's tale. And again, it's translated in all these different languages, all these African languages. And then, I started reading the Black Panther when I was 10. So I stopped when I was 12, but I saw something like in '88, and I bought a 4-part series, and I ended up giving it to Sister Phyllis Purvis. She was an elementary school teacher up here, and I never got them back. I wasn't expecting to get them back, but they were, really good. So this is the ultimate Black Panther guide. So I'm just really, yay. So I'm just really happy about that whole thing, I think that's great. All right, now I need to unshare. How can I get back to where I need to? Stop sharing. All right, so how was your week or day? What's going on with you all? Everybody's
what? I'll share, because I really feel like since I've been a vegan, that I have been so much calmer and relaxed. And, it just happened as soon as I joined WOSE that the opportunity came, and I took it, and I have still been with it. It's since, I think I started July 4th, the 6th, 2 days before we actually started, or a few days before we actually started. But I've been holding on, and I honestly think that like that whole thing about adrenaline being in the animals and stuff like that, like it must be true, because I'm just so much more calm. So yeah, feeling great.
Well, good for you. Good for you. That's good. You're doing a little reconnaissance work.
Debbie, you should let Dr. Jones know that it has that impact on you. He'll be tickled pink to hear that.
Okay, I'll send him a note. I'll send him a note.
Yeah.
How about you, Afua? What's going
Just
on?
had another inspiring, wonderful week. Part of it had to do with hooking up with different things with Jose, and also, you know, with my friends and family, walking, being able to walk, and then
Do
today,
you walk
walking
around the
with the
lake?
fresh air. Huh?
Do you walk around the lake?
I sometimes, because it's so close, I can look out my window at the lake, so I go down on the bay,
Ah,
you know, down at Berkeley Marina and, you
yes,
know,
yes,
Emeryville, and,
yes,
you
yes.
know, I do that with friends.
You know,
And so we do like a 3-mile walk, you know, about twice a week.
I really loved that. That's what I miss about the Bay Area. I miss Redwood Park,
Oh,
and I miss going to the marina at the end of University, and then
yeah.
you know, over there on Powell. You know, you go around that way. Yeah,
Mhm.
yeah, that's great. That's great. Yeah, I need to start walking more. I kind of put it on hold since all this smoke. Dondi Way, I was thinking about you. You know what you shared with us. Um,
Thank you.
are things a little better or improving?
Oh,
Mm,
it's a process, right?
yes.
And just take it one step at a time. It looks like the family is gaining footing and getting the services together, and
Mm-hmm.
they have a crowdfunding fundraiser that's going on. So it looks like they got everything together, and services will be on the 24th and the 25th. And the gentleman, his father's funeral services are tomorrow.
Mm.
Hmm.
Well,
So it's a process.
yeah, yeah.
Mhm.
Well, we wish you all the best.
Thank you.
And I know it's difficult, and it's in stages too.
Yeah.
Yeah.
Well, I'm really busy. Yesterday we delivered 500 over 500 meals. So
Congratulations! Oh, wow,
yeah,
that's
yeah,
Lot
we
of
fantastic.
meals.
delivered over 500 meals. So
Wow.
yeah, I have been busy. Was happy to see a volunteer this morning when he walked into the church. So yeah, I've been busy, but I've been stay prayed up regarding those two. You know, she's transitioned, and he has to face a lot of things going forward right now.
Mm.
Yeah.
Yeah. Yeah.
But the organization has me on my toes. That's why I'm in the car right now. Today we delivered 150 meals. So.
That's
And
fantastic.
then I'm at Veggie Grill because I'm hungry. How about that?
See, another vegetarian.
I have food all around me, and then I go to Veggie Grill.
Yeah, there you go. Now, is that the one that used to be Quickways over there on
Oh,
Grant?
I've gone there. I don't think it's called Veggie Grill. I'm in Mountain View. Again, I live in
Oh,
East Palo Alto, so
uh-huh.
I'm in Mountain View right there. But I visited the ones that used to be Quickways. Mm-hmm. Pretty good stuff.
You know what? It's just funny to me that's a vegetarian place. You know, because
After Quickways,
I
huh?
used to go to Quickways there, and there was one over there on Telegraph by Capwell's, which is no longer there. So yeah, wow. I didn't know you lived in East Palo Alto, in Nairobi,
Yes,
in
yes.
Nairobi.
Little Nairobi. Since the late 70s, we moved here from Houston, Texas.
Ah,
Mm-hmm. Yeah, in the 70s. Yeah. Mm-hmm.
Baba,
yes.
you know the vegan mob, that's the name of that restaurant.
Vegan mob. Yeah.
Yes. And it did used to be a quick way. And I'm not sure about this because I haven't verified it. But one Sunday, a few months ago, we had Minister Lazelle's son on there. but it's black owned.
Ah,
And I remember him saying he was part owner. The chef is one person and the owner is somebody else. But I have to verify that to see if Minister Lazelle's son, because he did have a restaurant and he is a chef. So I'm not sure if that's his restaurant or not, but that is really good. And a quick little story about that. I haven't eaten meat since 91. I eat turkey sausage, that's all. I really, really missed my breakfast meats. But I haven't had chicken or beef or steak or any of that since 91. But so I go to the vegan mob and they have these little chicken patties that are made out of soy. And those are really good. So I go there a couple of weeks ago and they say, oh, our chicken has changed. So now they give you a little chicken on a stick. And Baba, it was so close to real chicken, I couldn't eat it.
It tastes just like chicken.
It was moist. It was moist on the inside. It was juicy, and it was chicken on the stick. I called my granddaughter. I said, "Oh, Chanel, I'm saving this for you because I can't eat it." It reminded me of real chicken, and I could not eat it. That was so funny. I was like, it's not chicken, but I couldn't do it.
Yeah, I stopped eating. So I stopped eating pork in 1975, and I stopped eating beef in 1980. But I just held on to chicken, and I stopped eating it in 2013. Okay. So I haven't. And those of you that have ever observed me eating, that is like a major thing, and I haven't had any, and I haven't had any Sobeys or Snapples, which was, a part of my routine. So I'm working on myself, but Debbie, that's great. Vegan. Yeah. That's outstanding. Kat, have you graduated over? What's going on with you there?
Well, I'm not a total vegan, but I'm mostly vegetables and chicken.
You know what? I haven't asked you. How's Arlene doing?
Arlene is doing well.
Uh-huh.
Yeah, she's doing
good.
well.
Please give her my greeting. And I don't see her.
Yeah,
okay,
will.
Yeah.
Mm-hmm. Yeah, it's been a pretty quiet week here for me. Had some automotive issues that I had to deal with yesterday.
Yeah.
And Monday, the air quality was so bad, I just kept myself inside most of the day. Did some sorting.
I just want to let everybody know that our speaker is trying to get on, and so I'm thinking that Darnisha is assisting her in that way. So that's why we have not officially started. But I liked finding out what's going on with folks.
Mm-hmm. Yeah,
so thank you for sharing. I shared my new books. I just got some books. I think you were on though, so I won't bore you again. But I got a Ptahhotep and the Peasant's Tale, both by Arma, translated into like 12 languages, 9 African languages.
Oh, he has new books. Oh, that's wonderful.
Yeah.
One of his books that I found so intriguing was The Healers. Baba, did you read that?
You know what? I have not read The Healers.
Oh, you have to read The Healers.
That one.
Minister Emma.
Yes.
Magina. So speaker is rated if you want to.
Great.
He is on.
She's here?
Yes.
All right. Well, that's outstanding. So let me unmute her. Madam JFK, we're so happy that you've joined our Black Knowledge Matters sessions, and she has no video, please. Okay. Oh, all right. That's fine. But I'm glad that you joined us, and I'm hoping that you can enlighten us about generational wealth. We had a great discussion last week with Celeste, and coming in from Indiana, and she gave us some really good economic and financial basics, and so we're kind of in this economic financial mode, and so makes you the next contestant. So if you wouldn't mind, introduce yourself, and we're all ears, ready to listen to what you have to present to us today. Oh, you're muted. You're muted.
Okay.
Okay, there you go. There you go.
Okay, wonderful.
I'm getting some kind of echo. I don't know why.
It's because, Jeanette, you've probably got your two devices on, so you need to turn the audio off of the one that you're not using for the speaker.
Oh, wow, I see. Okay, so I'm using two forms of technology so that
You're clear now.
Okay.
Well, now you went into echo again. So turn one down.
Okay. Oh, you know, let me.
Think that it's nope.
That's not it.
That's strange. Okay. Are you able to hear me okay?
Yes.
Okay.
Oh, it's good to see you. Okay, I've never met you, and it's good that you're visible, and we're glad that you're here, and so please take it away.
Okay. Well, my name is Jeanette Fisher-Quadjo. I get to be called Madam JFK for short. And what I do, I like to call it generational wealth building. So I try to educate people about the benefits of having an estate plan, because that's one of the cornerstones of building wealth in this country. That is that you may own a home, or you acquire a certain number of assets, and you're able to pass those assets on to the next generation. They can build upon those and then pass assets on to the generations thereafter. And so what I find is that that's one of the primary ways that we lose wealth in this country. I just want to make sure that audio is coming in okay. Okay, wonderful. Okay, so you're getting two profiles of me. For some reason, my phone is on the computer, so you have two images. So now I'm not hearing you.
One is just your face, and the other is like your phone with a line through it. So we're
oh, okay.
But yeah.
Okay. All right. Well, so let's see, where do we start? So how many people have gone through probate or know what probate is?
I would like to find out about that, because I'm trying to persuade a parent, hey, we need to do some type of trust. Otherwise, we'll be in probate, which is an adventure in pain, I understand.
It can be. And let me just say this. So probate occurs whenever we pass away. Whatever we own in our own name becomes part of our probate estate. And so if you have a will, or if you don't have a will, guess what? You're still going to go through probate. So a lot of people think that a will help you avoid probate. It doesn't. It is good to have your wishes and desires written down so your loved ones can follow the instructions, and avoid family fighting, and just people are grieving and they're trying to handle this process. And the way that it's set up legally is that there's a personal representative that's assigned, or whomever the decedent or your loved one would have named in their will to administer their estate, the attorney has a direct line of communication with that person, but the attorney cannot communicate with the other beneficiaries. So sometimes the beneficiaries feel slighted or left out, and there's suspicion that arises, but it's just because the attorney represents the personal representative, and the personal representative represents the interest of all the beneficiaries. So, you know, there are ways that you can try to alleviate or avoid those problems just by explaining to the beneficiaries. I like to do a meeting with the family where I just do an informational meeting about the process of going through probate, what the time frames look like, so they have a ballpark idea of what's going to happen. And then it's helpful in San Francisco that everything is online. So that's the other aspect of going through probate. It's a public process. So anyone that wants to look online can find out what's going on or how you have decided to pass your estate on to your heirs. So some people, one, you want to avoid probate because of, you know, the possibility of the adventure in pain that you mentioned earlier. And then also because it allows an opportunity for, I'll say there's expenses that you'll have in probate that you could avoid if you had a trust. So for instance, in probate, the fees are set by statute, and it's a percentage based on the gross value of your estate. So your estate is worth $1 million. That's 23,000. I just know the formula, but it's about 23,000 for the attorney as a statutory fee, and it's 23,000 for the executor or the personal representative. And then there are these fees that we would normally pay if we were going to sell a house, a real estate commission or a property appraisal. But when you do it through probate, there's court-appointed people that have to do it, and the fees are much higher than it would be if it were just a private sale. So for instance, you have a house that's worth $1.5 million, which is, you know, not uncommon. Well, your probate appraisal is going to be 0.1% of that. So now an appraisal that may have cost you $500 is going to cost you $1,500 based on that formula. So there's some fees that you can avoid having outright. And if you have everything written out and your instructions are clear, then why have an audience to do that? You know, so the trust gives you an opportunity to, or your loved ones an opportunity to carry out your wishes in privacy with the assistance of an attorney. And so let me just backtrack a little bit. So we're talking about probate. If you have a will, if you don't have a will, you will still go through probate. Now, if you have a small estate that is valued at $155,000, and mind you, $55,000 is the value of property. So if you have real property and it's valued over $55,000, then you're not usually that administration of a small estate process is not going to be available to you. So let's just assume that you have a home. And if you do have an estate that's smaller, then you know the will would come in handy for that because it nominates someone, an executor, but you don't necessarily have to go through the process. You can use that as guidance for the most part. However, when you're dealing with bank accounts or any other entity that holds money on behalf of your loved ones, they're going to want a legal determination that you are the representative of the estate. So again, you know, to the extent that you can avoid having any of your assets pass through probate, you should definitely do that. So that's one of the primary benefits of having a trust.
Now, so what is the difference? You know, I hear these terms, revocable and irrevocable trust.
Oh yeah.
What is the difference of that?
You know, so what I like to tell people, we'll start with the revocable trust. So it's just as the name would indicate, you can revoke it. It's revocable, but so you can cancel the trust.
Jeanette, are you there?
Looks like we lost her connection. I saw her go
Oh,
for a
okay.
minute. Give her 1 minute. I'm sure she's dialing right back in.
Okay. Okay. How's this going so far for you guys? You know, this is these are important things because you don't want to leave people holding the bag. And then, like I ran into a guy that I knew. Let me know when she comes back on, Darnisha. A guy that I knew, and you know, he's a UPS guy, and he was somebody I would always wave to, you know, when I was at work, and our kids were born around the same time, and I was walking around my house, and he was driving his UPS truck, and he recognized me, and we stopped and talked, and then he was talking about he was going through probate, and it's been 2 years. Ugh. You do not want to have to go through that, man. That's, you know. So I'm glad we're getting some tutorial on that.
I went through a probate process, and it took about
She's
6
back.
months.
6 months.
Yeah.
Minister Imhotep, she's back.
Okay, she's back. Okay, good. Thank you, Kat, for stepping in on that. Jeanette, are you there?
Oh, I think she's back.
Okay, she needs to unmute herself, if she can unmute. All right. Oh, I'm sorry. Okay, unmute. I muted you, and okay, there you go. All right.
Okay. That was wonderful. But,
Where's that train? Is that at your house?
oh my goodness. Okay. Can you hear me okay?
Now we can. Yes.
Okay. So I just have to turn it off. Somehow I have 3 connections, but I heard you talking about probate and it lasting almost 2 years.
Yes.
It can last longer. And it can be very quick. 6 months to be exact is about the quickest you'll ever get through probate, but typically 1 year to 2 years is what it takes depending on the questions that are being asked. So at what point did I lose you all?
You were
about the irrevocable trust.
Yes, revocable, irrevocable. So usually, so the wonderful thing about a trust is when you set it up, I try to let people know what you set up, you can change. It's not etched in stone. So during your lifetime, you can make amendments to your trust. You can revoke it entirely. You can change your mind. And so what your trust does is to really lock in what your wishes and desires are as of the time that you make it, which is why it's important to review your estate planning documents periodically because things change and you want to make sure that the document responds to the reality. So that's a revocable trust. And it's revocable by the trustor or the grantor, the people that created the trust. Now, upon your death, it becomes irrevocable. So whatever's in place, that's what it is going to be in terms of administering your trust estate. So the irrevocable trust, usually that's, as the name suggests, this takes away the trustor's or the grantor's ability to make any changes to the trust. And usually you'll see an irrevocable trust if you're dealing with life insurance. So there's a life insurance irrevocable trust, and that's to basically keep the value of your life insurance policy out of your estate. Because guess what? Although it's going to benefit someone else, it is considered a part of your estate. So I don't see that happening as a practical matter where people have included the life insurance, but as the law states, the value of that becomes part of your probate estate. If you're the insured, you're the person that's insured and you're paying the insurance. So little small note there.
Oh, yeah.
And then a revocable trust will shield you from instances where another company might just disregard your trust because, so for instance, for people that have that receive any state or disability income, sometimes they just treat the trust as you having that value of assets on hand, because you are the one that can direct whether or not monies are paid to you. And so they just treat the trust as just part of you. And so if you have an irrevocable trust, then you have the possibility of maybe getting around some of those restrictions.
Thank you.
So shall I continue on, or does anyone else have a question? I know there was another gentleman talking when I got back on. Okay, well, I'll tell you some more.
I have one question. Yes, if if you have a revocable trust, you can, I'm assuming you can put into it pretty much what you desire or what you choose.
Yes.
You know, so you could like put in a financial portfolio. But so my question is, would you still have access to that portfolio in terms of making changes if you so choose?
So you know what, let me just give you a little more than what you asked me, because when you're dealing with estate planning, there's a lot of moving parts. You have the legal part, you're trying to avoid probate, and then you have, you know, your financial institutions and your stock and security companies involved. And so in addition to looking at the legal aspects, you also have to be mindful of what the tax consequences are of what you do. So I heard you mention having a financial portfolio. So that's one of the things that you really want to, you have to deal with it on a case-by-case basis, because in some instances, individuals, we have certain tax benefits that a trust just doesn't have. So you want to be mindful as to whether or not it's going to be more fiscally beneficial for you to have the asset being owned by the trust or being owned by yourself, in your name. And then the other thing is when you have stocks or securities, mutual funds, even banks, you have the possibility of, with banks or financial institutions, you can have what's called a pay on death provision, so that at your passing, you can designate who you want those funds to go to and at what percentage. That keeps it out of probate. It's not considered a probate asset, but they won't be able to access the monies until a certain number of things have transpired. They need to have a certified copy of your death certificate. That's the primary one. And then they also, sometimes you have to wait 40 days. When you have retirement or you're dealing with mutual funds, stocks and bonds, they automatically have you designate a beneficiary. So when you set up the account, so any with any entity that you deal with, if in having an account or having a business relationship with that entity requires that you designate beneficiaries, then already that's taking you outside of probate. So it's not subject to probate. You've already designated who those beneficiaries are. The beneficiaries will need to contact the company. The companies don't contact beneficiaries. So that's the other thing. So it's a very good idea to have all that paperwork in one place so that people will know where they need to access what you have. So that's my long answer to your question, because you may not want to make your financial portfolio part of your trust assets.
Thank you.
Okay, so it's very easy, as you can see, to talk about one thing and then to just go completely down this, I won't call it a rabbit hole, but just an area of interest. So I'm gonna just touch on some things that I think you should just be aware of. So some of you may or may not be familiar with what a basic estate plan is. I like to call it a peace of mind plan, because once you do it, once you set it up, you have peace of mind. So people have a lot of anxiety around dealing with estate planning. It's as if people are saying, oh, you're gonna die soon. What are you gonna leave me? And it's the farthest thing from the truth, because what's happening, you'd be alarmed at the number of young people that are passing away. And so you just want that in place because basically it's a tool to help you save money, reduce your taxes, and just maximize any benefit that may be available to you. So in essence, I like to ask people, how much money would you like to pay an attorney or a court or any number of people before your loved ones can inherit your estate? And usually people tell me nothing. They don't want to pay anybody anything else. And I just start by saying, well, this is what will happen if you do nothing. So we already talked about probate, and we just used the value of an estate, $1 million. Already you're looking at $23,000 in fees for the attorney, for the personal representative, plus the court filing cost, that's $46,000, that's $50,000. And usually what happens, in order for your heirs to have legal title to your assets, they have to close probate. Well, in order to close probate, you have to pay those fees. So we already talked about $50,000. So usually a lot of estates may not have enough liquidity to pay those fees. And then that forces the family to have to sell the house. And then if you have more than one beneficiary, unless they all agree to retain the house or execute some kind of buyout agreement, well, then you're forced to sell the house anyway. And so then add on a real estate commission of 5 to 6%. So you're at, $110,000 real estate commission and the probate expenses. So you want to do what you can to avoid that outlay of cash and use that for something else other than, just adhering to the statutory process of probating an estate. So what you want is, the peace of mind plan is what I call it, and it consists of a trust, a revocable trust. And the revocable trust, what that's going to do, the primary benefit is it is going to help you avoid probate for the assets that you have placed in the trust. So the number one thing you want to put in the trust is your house or real property. And then any of your financial accounts that are liquid that have a appreciable sum. If you go over a certain amount, it's going to be subject to probate. So you can transfer bank accounts into the trust and things of that nature. And that's one of the ways that you can minimize costs to your estate. I'm going to talk about the other 4 parts of the peace of mind plan. And then what I'd like to do is to just share with you some of the problems and issues that I'm seeing in court or dealing with documents. And so that for those of you that already have trust, you need to update them. For those of you that are thinking about getting one, and I do encourage you to do that sooner than later, that you'll have some of these ideas in mind when you speak with a legal professional that will assist you with that. So you have the trust, the revocable trust. That's the first thing. The next thing you're going to have in your peace of mind plan is a pour over will. And it literally gets its name pour over because what it does, it serves as a beneficiary.
I'm sorry, could you repeat what I wasn't clear what you're saying.
Okay. So I'm going over the main components of a peace of mind plan or a basic estate.
The second one, you said pull over? Did you say pull over?
Pour over.
Pour over.
Pour over. So it's a pour over will. So unlike the last will and testament, where you give gifts to individuals or entities from the document, the pour over will is like a safety net. So in the event you left anything out of your trust, anything that you've left out of your trust, your pour over will literally pours it into your trust. Your trust is the beneficiary of the pour over will. And so these are very important because sometimes people have trust. You think that the property's in the trust, but when it comes time to sell the property or go through title, you find out that there's been some errors in the recording of the document, or it could be a document, before that one, 2 or 3 times in seniority to the trust. So anytime there's an error in the record, of title, anything recorded after that record is also outside of title. So it's, you know, lots of little things. So the pour over will help you avoid going through probate. So sometimes people, I'm a real estate broker as well. So sometimes people will sell a property. They think that it's a trust sale. The property's in the trust, only to find out that, you know, it's not. The owner never transferred the property into the trust, or the owner transferred the property into the trust but got refinancing done. And usually the banks or financial institutions are going to require you to take the property outside of trust. And so sometimes people never put it back in. So this is a safety mechanism. So if you have that pour over will, then, you know, normally you would have to go through a probate process, but you can have what's called an 850 petition filed. And that's where, you know, I would just represent to the court, you've set this trust up, you included this property as part of the trust. It was your intention that that property be part of the trust. And you also have a pour over will, which would transfer the property to your trust if you had to go through a probate process. And so usually if you have those things in place, the court is more inclined to grant you an order confirming the property as a trust asset and not requiring you to go through probate. So that's the second one. The third one is a durable power of attorney for finances. So the durable power of attorney for finances is just a document that you designate someone. Sometimes maybe it's the same person that you would have to be your successor trustee, or maybe it's the person that you would have to be your executor. So the agent in a durable power of attorney for finances, you're basically giving them authority to make financial decisions for you in the event that you're unable to do so. However, because it's durable, so if you're ill, it's still valid. So that's the importance of a durable power of attorney. So whenever you sign it, it becomes effective. So you want to keep that within your control until such time as you would like to relinquish the authority to the agent. So that's the only caveat with that. So you have the trust, the revocable trust, you have the pour over will, you have the durable power of attorney for finances, and then the fourth thing is the power of attorney for healthcare. So in the same respect, in this document, similar to the durable power of attorney for finances, now you're dealing with your healthcare. So in this document, you're designating someone to make medical decisions for you in the event that you're unable to do so. And when you don't put this, yes.
I'm sorry, can you back up a moment to the durable power of attorney for finances? Because you were saying once it's, take me to that process again. It sounded like if you made one, then it was already in effect, and that has some sort of problem?
Yeah, so we used to have what's called a springing power of attorney. So in essence, it would spring into action, or its authority would take place at some time in the future. There were a lot of problems with that. So people don't use those much anymore, if at all. So there's a durable power of attorney. That document, so as soon as you sign it, so what happens with the durable power of attorney, you're basically giving someone, your agent, the power to act in your name any way that you could do so for yourself with respect to your financial or business affairs. So as soon as you sign that, you've executed your part. Your agent would then also have to have their signature notarized that they accept that authority that you've given them. So what I said is that you need to make sure that once you do that, until such time as you want the person to actually have the authority, you keep the durable power of attorney within your possession. Because as soon as both of you execute it, it is a legal document that could be relied on by a third party. So you keep that with your estate planning documents, and when it becomes necessary, you allow the person to access it or use it. And it could be that you're on vacation, you're out of town, any number of things. It's not just death. And what it does, it overlaps a bit the power of a trust. But when you have a trust, usually you're not relinquishing control to that authority until such time as you have to for incapacity, or perhaps you just, you don't want to deal with the business anymore and you're going to let another trustee, a corporate trustee, handle it. So usually that's your role as a trustee is one that you don't want to relinquish often, if at all. Usually it's relinquished upon death. So when you have the durable power of attorney, that functions, the power of attorney is valid during your lifetime. It seeks to have any power after your death. So that's one of the benefits of the durable power of attorney, is that people can use it for a temporary period and for certain matters, and the trust continues on beyond a person's death. So the thing about the durable power of attorney is once it's executed, you want to keep that within your control so that you're not simultaneously giving control to someone else while you still wish to make those decisions for yourself. Did that answer your question?
It did. I guess what I'm thinking of is a situation, if you can't make the decision, you're in the hospital, but you're not capable of saying, go look in the drawer and get out the durable power of attorney. They don't have it. But if you give it to them now, then they could use it now.
Okay, well, that's a good point. And it brings us right to the next document, which is the power of attorney for healthcare. So your durable power of attorney is valid for your business matters. So the next document that you want to have in place is a power of attorney for healthcare. And it's specifically for that reason that you just indicated. It's to provide legal authority for someone to make decisions on your behalf, medical decisions on your behalf, when you're unable to do so. So you definitely want that in place. And that document, along with your wishes to be kept on life support, depending on what your chances for recovery were, or if you wanted to what do I want to say? If you wanted to donate organs or anything of that nature, that's going to be part of your power of attorney for healthcare, and that's usually joined with the advance directive for healthcare. And the way that the doctors are going to be aware of that issue is that you're going to give a copy of that document to the medical provider. They're going to have that on file for you. And usually if you had an emergency, that's going to be one of the first things that the hospital wants to know, is if you have an advance directive on file. And so in that document, you'll be designating responsible people to make healthcare decisions for you. And so it's not uncommon that sometimes the same people that you may have designated to be an agent on your durable power of attorney for finances will also be the people you designate on the power of attorney for healthcare.
Hello, this is Bobby. I just wanted to add that I did this about 2 years ago. And I cannot stress how important it is. And you only have to do it basically one time. And I had a meeting with some of the family members that are involved and gave them a copy of it. Okay, so they know. They thought I was dying. I said, no, I'm not dying. I'm just trying to straighten out my business, because I didn't want them to bury me in the backyard with the dog. Okay. So I had to get my family straight. And I'm actually paying for my own funeral services and stuff. But I at least wanted them to know, like, I think Celeste mentioned, I'm in a hospital and I can't speak. I just kind of want to talk to them and just kind of see how important it is. And actually, I'm making them responsible.
Yes.
To take care of me, whether you like me or not. You're going to take care of me in my last wishes. So
Yes.
It is important, and you'll be surprised what kind of comes up in those conversations, sitting down with your family and say, here's my copy, blah, 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 you know, and just kind of highlight it. And it actually went very well. You know, it went very well. So, yeah, so that's what I did. And that's just one thing, a goal that I wanted to do. I gave myself, like I said, before the end of this year, I'm going to do this. You cannot keep procrastinating. Because like you said, something unexpected can happen.
Yeah.
And be a financial burden on the family. So that's all I just wanted to add, that it's how important it is to do that.
Thank you so much for sharing that. I appreciate you for taking that step and involving your family. It's always good to just let people know that you have something in place. I want to just caution you, you want to be careful that people don't rely on any gifts that you've given them in your estate planning documents, because you still have the right to change your mind, but you create a kind of liability if they have acted, you know, in reliance on that. That would be the only thing. But you know, just like you said, I think our families, what I noticed is that they will follow your instructions if they're written. Right. And sometimes they may not like it. And then it may not, there's no menace involved. It may be that you've discussed your wishes over your lifetime. So you just talked with one family member, you know, about what you wanted to have happen, and you've changed. Some people have changed from wanting to be buried to being cremated, which, you know, wasn't the case. And so whatever you tell each family member, they don't know what you told the previous person or what you will tell the one after them. And they all feel like they're fighting for what they believe are your wishes. And a lot of times you just, you know, your opinion changed over time, and it's just not they don't have all that information and feel like they're just doing what's right for you. So.
Right. And I also told, and you're right, because I did tell them, even though, you know, I have life policies, I didn't tell them how much it was worth, but I did tell them I'm spending all my money, and if there's any money left, I miscalculated. Okay. So whatever left, that's go, Bobby. Let's go. Ain't that go? Let's go, Bobby.
The situation that.
And Bobby, this is Darnisha. I just keep going to graduate school, so my children go owe so much in student loans. I'm like, y'all figure that out too.
Well, let me just let you rest assured that whatever your debts are, they don't belong to the people that you that inherit from you. Now, if you go through probate, that you know, this is where, you know, so creditors are looking at all the probate cases, because we have to have legal publication that notifies the public, and you're required to notify any known creditors. So then creditors can make a claim against your estate. But if there's not going to be a probate estate, well then, you know, usually they don't make those claims. So, but typically whatever your debts are, those are your debts that will be paid from your assets. But that's one way where sometimes the creditors that would have access to your probate publication, they don't have that access when you are having a private trust administration. So again, if they're creditors that you know about, then, you know, usually you want to let them know that the person has passed away. And usually you can let them know that there won't be a probate estate. They may, or probate administration, they may ask that. I find it incredible that they seem to be so unfamiliar with trust when they've been around for such a long time. So I would never advise you to do anything that, you know, was to the right or to the left of the law, but this is the difference in the public administration and the private trust administration.
So Ken, I don't know if I came a little late. Did you talk about pricing of how much the range, what a fair range for because I can tell you how much I paid for my living trust.
Mm-hmm.
You know,
no,
but
I think
what's a good price, or depends.
Well, what we talked about was the cost of probate, but what I can tell you about trust and estate plans that it depends. It depends on the value of your estate, how complex it is, and then what it is you want to have done. Now, for a, just to give you a starting point, for a complete estate plan, usually for couples, I'm going to say it's anywhere from 6,000 to 8,000. That's simple. And it could be less, for individuals, for the complete estate plan. So, and I wouldn't recommend having an estate plan without the other documents, because you'll find yourself uncovered. But for individuals, they can range anywhere from 5,000 to and up, depending on what your assets are. So some people have a lot of property, some people have businesses, some people have a lot of different working parts. So those are pretty much your starting points.
I have a question.
Oh,
sure.
Go ahead, Debbie.
I have a question about corporate executors. So currently I have a trust, and my executor is my best friend. Mm-hmm. But we're the same age. And so, you know, like as I get older, she gets older. And so I was just wondering about, do you have an opinion about corporate executors?
Okay. So I think that are you talking about a corporate trustee?
Yes.
You mentioned
someone to handle the trust.
Okay. So normally if you have a trust, then you can name a trustee, a successor trustee. That person can be an individual. Some people, so people that have, you know, really complex estates or just the high net worth estates, or they're just able to do it, is they will hire a corporate trustee. And usually the corporate trustee will work in conjunction with a successor trustee that they've named. So I want to make sure I'm talking about what it is. I want to make sure that I'm answering your question. There's a lot of terminology that we kind of mix up. But so I'm glad you brought up that point, because that is what I see, is that when people, and I'm looking at elders, and when they have documents, they've named people that are their colleagues. And so the problem that you mentioned is the very same thing. If they start to have health conditions within a lot of people that they've named to be successor trustees may have those same conditions. So you want to think about that. And, you know, you never know what will happen. Sometimes, so that's why when you name a successor trustee, you want to name more than one. So you want to think about that when you name the people. They need to know you, be familiar with what your wishes are. And then you also want to think about, you know, who would be the next person. And you could look at things like age and their level of responsibility such that you know it. So that's a very good thing to do, is to kind of vary the people that you choose. There was another part to your question.
No, that was actually,
that was it.
Yeah, that was. So if do you recommend using a corporate? So I don't necessarily, I wasn't thinking about having my friend have someone to support her. I was wondering if I should just go outside, because I went to court once for my sister, and there was a person there who was a corporate, I'm not sure what you called it, but he wasn't related to the family, but he wrote checks and took care of the trust. And he was actually there asking the judge if he could get a raise for his services.
Right? Professional fiduciary. Okay. Does that sound right?
That
so the fiduciary,
right.
Yeah, so an executor, a trustee, and so forth, these are considered fiduciary roles. You're handling the assets for someone else on behalf of another entity, not for yourself. So sometimes people that are in court, and this brings me to, this is going to dovetail the power of attorney for healthcare. So you may have seen a court-appointed attorney for a conservatorship estate. So conservatorship, if you're under 18, you need a guardian. If you're over 18, you have physical or other challenges, then you need what's called a conservator. So you're
That must
gonna,
have been it. Yeah, that must have been it because I was conservator for my sister. That was probably
okay,
the right. Yeah. Okay.
yes. But all three of those things that you brought up are very interesting. So I'm gonna just answer all of them. So you don't want the court appointed attorney. I mean, that's okay, but pick who you want. And usually those court appointed attorneys are coming into that role because there's been maybe a court appointed conservator, or it could just be, usually the family members can do a number of steps to become the conservator, but then you then get a court appointed attorney to help you in that role of conservator of the estate. So what I find is that when you set up your trust documents, the people that you name as successor trustees, you're going to already name them as conservators of your estate. That's essentially what they do. So they avoid conservatorship for you. You don't have to have that process. There's no gap. Whenever you don't have the capacity, you already have someone in place. Now, in your power of attorney for healthcare, your advance directive for healthcare, you're going to name agents that are going to make medical decisions for you. So already in that, if anything happens to you during your lifetime, and you have that document to rely on, but you also have you have the authority that you're granting people in your trust to do to handle both those roles. So that's very important. When you don't do that, guess what? The doctors still need consent. So they're going to have to go to court on your behalf to get the medical power of attorney. So, who do you think is going to pay that expense? And it'll probably be much more than, setting up a complete estate plan. So,
Right.
and the last thing that we're talking about was the corporate trustee. So what happens, the reason why people have them or they don't have them is because corporate trustees usually have a fixed annual fee, a minimum annual fee. So if your estate is not at a certain amount, then it doesn't make sense to do it. Or if your estate is primarily real estate and it's not rental real estate, you don't have liquidity, then you're paying an annual fee. So I know several years ago, maybe they've increased it. It used to be that you could have one bank was offering their trust services a minimum of $2,500 per year. And that's because your estate had to be valued at least $250,000. So they're charging you a 1% fee. So if your estate is less than that, then the cost needs to be worth the services that you're going to get. So I hope that all of you need a corporate trustee. And one of the things that I hope to move into is being or offering corporate trustee services, because what I am finding is that, you have the professional fiduciaries, and a lot of them are, they're from various cultures, not always our own. And to give you an example, there was a woman who was of Jewish descent, and she needed a conservator. So whenever you need a conservatorship, that just goes out to the public, and any professional fiduciary can apply. No, I told that story wrong. The woman was of German descent. And guess who applied to be her conservator? It was a Jewish organization, a fiduciary from a Jewish organization. And so I would like to believe that we would all adhere to whatever role we've been appointed to play, but we're people, we have biases, and the history between Germans and Jews is, I just wouldn't want that to be the first person handling my affairs when I'm, in an incapacitated state. So you want to be the decider. So now I think that got us to the end of those documents. We have the trust, the pour-over will, the verbal power of attorney for finances, and we have the power of attorney for healthcare and the advance directive for healthcare. So that pretty much covers all of it. The last thing is what's called a certification of trust. And this is just an abbreviated form of your trust document. I call it the need to know document. So whenever you go into a bank or you go into an institution and you have an asset you'd like to transfer it into your trust, this is what you'll need. And so it just has the provisions that are necessary for a company to work with you. It tells who the current trustee is, who the successor trustees are, what the trustee's powers are. So it just includes maybe 3 or 5 pages from your trust, depending on the length. And that's your summary document. So with all those documents, you have a peace of mind plan. You've covered all your bases. And if you add more property to your portfolio, well, then you would add those to your trust and so forth. And a lot of what you do in the trust, you're thinking about plan B and C. So even though some things may change, it doesn't always necessitate that you have to do an amendment to pull that item out. So if you name someone and they were to be your successor trustee, if they passed away or if they just couldn't do it anymore because, you know, I don't know, they decided to move to another country, then, you know, your second person or your third person would then be the next individual to have that role.
So,
okay.
Now I have a question, Jeanette. Do you do this kind of, do you do this?
I do. I do probate, and I do trust. I do estate planning. I also do webinars like this, where when we pre-COVID, it would be a seminar. I'd be invited by a group to just speak to their members, and I talk about these things. And
so, are you going to give us your information?
Yes, I think that I will definitely make sure you have it. I think that Darnisha may have it, maybe post it in the chat, but I'll make sure that you have it. Yes, by all means.
Yeah, I will make sure that it's posted, Mama Engine, and it's also on the flyer for this Wednesday. Her number is on that flyer, but I'll send it out to everyone again and repost it on Sunday as well.
Okay.
Jeanette, did you say that if there was a mortgage on the property that it could not go into the trust?
No, but I'm glad you bring up mortgages. So let me just say, this is one thing common among Black people. If the item isn't paid off in full, we somehow don't feel like we own it. So with respect to a house, a car, so you are the legal owner. If you have a mortgage on your house, you're still the legal owner. Now that mortgage has a lien against the property for the value that it's owed, that institution, but you are the owner. And I just think that speaks to our integrity. And so yes, if you have a mortgage on your property, by all means, place it in trust. Because what happens is, sometimes people are ill and then maybe they had their bills paid automatically, but they didn't have a chance to set up an estate plan. So no one has legal authority to transact with the banking institution on their behalf. So guess what? If you don't have legal authority, you're no different than any third party that's walking down the street. The company can be sued if they provide your information to anyone other than yourself or your legal representative. So then there's a breakdown. So then what happens? You're ill, but people are consumed with just, making you comfortable and trying to deal with what's going on with a loved one physically. So no one is thinking about, is the mortgage being paid? And so it's not uncommon that after hospitalization, you have 3 to 4 months of mortgage payments that have not been paid. And guess what? That puts you in jeopardy of default, foreclosure. Yeah. And it just makes you scramble. And so in order for you to get legal authority, well, then you have to go through probate. And so you don't have to wait till the end of probate, but you do have to wait until you have a probate process or hearing set up, and that you are actually recognized, or your nomination of executor, assuming the person had a will, or if they didn't have a will, they follow California law. They follow your bloodline. So your beneficiaries are your descendants, your children. If you don't have children, then they look up the line to your ascendants, your parents. Your parents are already deceased, and they go over to your, your aunts, your uncles, and they just follow your bloodline until they find a relative living, and then that becomes the pool of relatives or people that are your beneficiaries. So I digress. Tell me,
Jeanette, I have a question about LLCs, and I may be going down the rabbit hole now as well, but can you does putting a property into an LLC offer you any protection as opposed to the trust?
Well, so if you go the LLC route, what's going to happen?
What?
Limited liability corporation.
Okay.
So sometimes so if you're an investor, you have real estate investor, you have a lot of different properties. A lot of people will put each property. I know one investor, he just put each property in its own LLC, and it was because he wanted to limit any liability from that property to the value of that property and not have it reach any of his other assets. So that made sense for him because it's a business for him. But in terms of, I'm going to just talk about maybe, people on this call, other folks, unless usually there's a business reason, you want to limit your liability, which is why you set up the LLC. And that makes, as long as that makes greater risk sense for you, then you would do it. But in lieu of a trust, but two separate things. So if you are trying to, and then also for people who want to keep a property within the family, that might be something that you do. You would set up an LLC, because what happens if you give a property to people, then they own it. They could do with it what they will. So if you have it in an LLC, then like with any other corporation, you would set up how shares are to be distributed. If someone wanted to be bought out, then their share would be valued at this amount, or, so you're treating it like a transaction, internal transaction that is governed by the documents that govern that entity, the LLC. What you don't want to do is, when you think about a trust and beneficiaries, so one of the things, let's talk about property. So if you have a property and you want to pass that on to your heirs, if you do it in a trust, then whatever the value of that property is as of the date of your death, then your heirs get a stepped up basis to that value. So let's just take the baby community. I'll say any community in this world. Who would have ever thought that, our properties would be valued at over $1 million? I don't think people really foresaw that. So let's just say they bought it. I think about my grandparents when houses were, $50,000 or under $50,000. They pay $50,000 for the property. If, let's just say you put it in an LLC, you're going to have, it takes you into a whole new tax bracket. So how you decide whether or not you do an LLC or a trust is you're going to look at what the tax consequences are, what your ability is to write off certain things, and you'll decide, based on that, as well as what goals you want to reach at whether or not you go to an LLC or a trust. Some of the benefits of a trust is that instead of me, when I received the house this year, and the parents pass it on to children this year, where the house is at $1.5 million as opposed to $50,000. Well, all the heirs have received an automatic step up in basis, which means they're considered to have inherited the property at the value that it is as of the person's date of death. So the property would be inherited at $1.5 million. If they wanted to sell it, they turned around and they sold it. Well, they arguably get $1.5 million or more, and they would not have any. They may have certainly less capital gains than they would have if they inherited the property at the rate that it was purchased. So let me just, I'm talking about three things. So one benefit for the trust is that you're going to have stepped up basis. The beneficiaries will have stepped up basis. So normally you would pay capital gains taxes on the basis, meaning the cost of the property, the difference between the cost and the value of the property when you inherit it. So if we had to rely on $50,000, which is what happens when parents say, oh, well, I'll avoid probate. I want you to get this house. I'm just going to put your name on title. Well, when you do that, then the person that you put on title is considered to have paid, you know, if it's just you two, then they're considered a 50% owner, and their basis in the property would be 50% of what your basis was. So that $50,000 is your basis for the property, $25,000 for you, $25,000 for them. So you've avoided probate if they are, you know, a joint tenant with right of survivorship, so that at your passing, they're considered to own now your share, but they still have the $50,000 basis. And if at your passing, it's worth 1.5 million, well, the difference between 1.5 million and $50,000 is what? 450 million. So the long-term capital gains are 20%. So now you owe 20% capital gains tax on 1.45 million.
And that's where we lose the property, right? You don't have that money.
Well, you end up having to sell it, and you were going to sell it, but now you just, a huge chunk of that money just, you know, what is that? 290,000 just went to the IRS when you didn't have to do that. So you were trying to avoid probate, but you cost yourself so much more money in another area, which again is why I say there's a lot of moving parts, and you want to, there's some things that you just won't think about because it's not your profession and it's not something that you just deal with every day. So I just cannot, as much as I am a shopper and I like retail therapy and getting a good value, you know, some areas you just want to pay for what it is that you're getting because the mistakes are very costly.
You know, I wanted to ask you, first of all, on my trust, I had to go to the bank and fund the trust.
Yes.
You know what I mean? Yeah. And how important is that? I did it on one account, but not all the accounts. I got kind of lazy because sometimes you go through this, you know, whole process. Because you got to fax the papers and stuff. So I did one account, but, yeah, you know, yeah, so how important it is to, and which I didn't understand, I'm glad he told me about funding the trust with the accounts. And then number two, while I have your attention, I also too had to list, which was good for me to dig up all this documentation. I had to list, you know, my accounts and life policies and stuff in there at the back of the trust, I guess, so they can have a list of all my policies and account numbers that, you know, for the attorney that I had to list. Because you can have accounts everywhere, right? And so it just kind of, you know, put it all together, and I probably have to update some too. But anyway.
Yes. That's a great practice, and I'm glad that you brought up funding the trust. So before I started doing this work, I had come back to Bayview and I just noticed all these probate sales. This is in 2003, so before we had that, you know, most recent, before this one, downturn. And I thought, why don't people have their properties in trust? And then I thought, well, why are people going through probate? So I thought, well, what could I do? I would do workshops to try to help people understand the benefit of having an estate plan, other than it just being an expense that, you know, they don't appreciate having presently. And then the other thing that I did is I went to the probate court and I just asked to review some of the probate files. And I was just looking to find out why people were still going through probate. What were some of the reasons that they were going through probate? And so one of the things, you know, that I see a lot. So when people go through services, I call I just kind of generalize and call it the binder service. You get this huge binder of documents, and a lot of it leaves the responsibility to you. And then I just see people, they've signed it and they just think everything's fine, and it's not. And we don't find out about it until they're passing. So that's why I know about it. And so some of the self-help groups, I had to, talk with them, because I constantly kept getting people from something called We the People. I don't know if they're still around, but they were just making so many mistakes. And so whatever money you thought you saved in using that service, you paid that, plus you paid a full probate. And if you tried to do it yourself and didn't have a pour over will, then, you just didn't have the benefit of that safety net. So I understood that people were trying to save money, but they were causing themselves problems. So yes, funding. So funding the trust is one of the things that I would do. I would say that, every attorney should do that. However, they do pass it on some to the client. And then also there's an additional fee for that, for funding the trust. I just include all of that in, whatever I do, but you, with respect to your bank accounts, you can have the bank accounts be part of the trust. That's one. And if there are other bank accounts, you can also do what's called a pay on death provision. And that's where you're designating a beneficiary for those funds. Now, just keep in mind that if these are funds that they would need to access to care for you or to handle some of your last or funeral expenses, they're not going to have them available until after you have a certified death certificate issued. So people aren't always aware of that. And even insurance, they need a certified death certificate. So if you, I know that you mentioned that you'd already started paying for your care and so forth. So it's a good idea with all your estate planning documents to make sure, I say just every year, just update a statement. So if you get an annual statement, December is a good time. Or January, you get a statement, just to include a copy of that statement of all your assets, your bank accounts, any place that holds something of value for you, to just keep a copy of one of those statements with your estate planning documents. And where you were mentioning that you listed everything in the trust, it's called a schedule of assets. And so that's part of, when you creating the trust, you designate what you consider part of the trust estate. A lot of times people stop at that. So sometimes some houses, they never went to trust. They were never recorded or transferred into the trust. So I think a lot more attorneys are taking that on as a responsibility. At least I hope that they will. And to avoid the case where you have completed this wonderful estate plan, but you have nothing in it. So it governs nothing.
I have two questions. One is, if you purchase a property in your name and then you need to move it into the trust, that would be a separate transaction you would pay for.
Wait a minute. So you set up a trust and you are
If I don't have a trust set up and I purchase a property and then I want to put it into a trust, I would have to pay to have that property put into the trust?
Well, so let me just say this. Whenever you get a trust, you're going to transfer your assets in. So you're not paying any more money by getting the trust. Now, if you set up the trust and you have a property, then, you're going to transfer that property into the trust. Usually, depending on, what you've worked out with the attorney that you work with, that may be part of the fee that you pay, or it may be an additional cost, but you will know what that is. Now, if you acquire more property and you want to transfer that into the trust, then there may be a fee for preparing your deed to transfer the property into the trust. So I hope that that's a problem that you have. I hope you acquire many more assets, but initially the trust, the price of your trust, which is why I say it depends on the value and the complexity of your estate, is how your fee would be set, because with each of those assets comes an additional document or work that needs to be completed to make it part of the trust.
And so my other question is, I'm single and I have one child and I want everything to go to her. Do I still need a trust?
Yes, you do, because that one child will have to go through probate.
Okay.
Yeah.
All right.
Yes, definitely. And here's
the way around that doesn't work because of the basis thing. Okay.
Yes, because I've had people, it's like, you just avoided $20,000 in probate fees, but you have a $200,000 tax bill that you didn't need to. Yeah. So, I say, when I tell people some of the pitfalls of what we do independently, I do understand, based on our history, that the courts were just not an avenue for us as people. So we have this concurrent process where we try to have the same outcome as the legal proceeding. But it just, and that was something that when we had to do it, we did. But when you deal with property, things that are in the public domain, so to speak, then ownership rules are going to be governed by the laws that be. So you definitely want to get the value of good advice. The whole point is to save you money. So until you recognize, if you just know what the cost is and you don't know what the benefit is, then it seems to be, unsupported. But the idea of the trust and of you setting up an estate plan is looking forward so that you can take advantage of tax advantages that are accorded to you under this type of ownership, but maybe not this other type of ownership. And just any number of things, whatever minimizes your taxes, retains your privacy, and then offers you the greatest flexibility, and also provides instructions for your heirs so that, you just are handling a multitude of problems before they ever get a chance to form, when you think ahead for your family.
Yes.
So one thing that I want you all to think about a little more, when you set up these trusts, and even when you have will, I want to dissuade you from relying on a will, because the whole idea is to avoid, one of the major ideas of estate planning is to avoid probate. So what I'm finding is that, people will set up trusts, they will leave a property, maybe they leave it to their grandchildren. So here's one other thing: leaving gifts to your grandchildren when their parents are still alive. Keep in mind, especially if it's real property, keep in mind that there's a property tax exemption that, just as I talked to you about a stepped up basis, that the beneficiary inherits a stepped up basis, the current fair market value of your property. Well, with respect to property taxes, there is an exemption. It's called the parent to child exemption. And that's when your parent passes a property on to you, you get to retain their property tax bill. So, those are based on, 1.17, 1.19, a certain percentage of the value of the property. So the tax basis on a property that was $100,000, let's just say it's $400 a year. And if you pass that property on to, say, your grandchild, and the parent is still alive, well, then you don't have that benefit anymore. So it would be just as if a new person bought the property. So then now your property tax basis is going to be set on the fair market value of the house. So instead of it being $100,000 or whatever your parent paid, now it's going to be the tax basis on 1.5 million. So now you've gone from owing, $400 a year on the property to owing more than $1,500. Excuse me, one, is that right? Yeah, $1,500 a year. And the math is off, but what I want you to just understand is that you know, every decision that you make has a consequence. So these are some of the things that when you do things on your own, or if you're working with people who aren't representing you in a legal capacity, then there's a lot of opportunity to miss these things. So that's what I want to say about parent to child transfers, grandparent to grandchild transfers. I also wanted to add that when you do that, when you leave property to your children or your grandchildren or whomever, bear in mind that each person may not be of the same mind. One person may want to keep the property, the other person does not. Well, so what has to happen if the one person that wants to keep the property wants to keep it, then they have to buy the other person out. And so they're buying them out at the current fair market value, 50% of whatever that is, or 50% of whatever a willing buyer wants to pay. And a lot of times that prices people out of the process of being able to do that. So if you have people that want to, you know, you want to think about that in the trust so that you can give them some guidelines. No, you don't have to put the property on the market to find out what is the highest bid and then have the heir come up with 50%, or maybe you do. Maybe you'll base the value on whatever the probate referee values the property at without having to put it on the market. That saves the, you know, the time for that process, and also lessens the real estate commission in half for that. One problem I see is that family members who you've allowed to live with you, I see this a lot where there may be, I don't know, a grandparent and maybe uncle or aunt or one of their children has lived with them or maybe came back to live with them. When you have people that are occupants in a property, they're not tenants because they don't pay rent. They didn't pay rent when the person was alive, and they just have a hard time even digesting that they should start paying rent after the person has passed away. So what happens is when you have people that are occupants in property, they can't buy anyone else out, and yet they only have a partial share. It creates turmoil amongst the beneficiaries because you have one person living there, not taking care of the expenses, preventing the property from being sold, and not in a position to buy anyone out. So even in your planning, I want you to think a little further, because this is where I start to see problems. And you see one person just taking advantage of their presence in the property, and it just creates ill will amongst the beneficiaries. So to the extent that you can kind of contemplate what people might like to do and include provisions in your trust to give them guidance on that, that is great. But to the extent it's not done, it's just an area where it disturbs, I'll say, the peace and harmony of the family. So.
Right, I'm going to let everybody know it's 6:31, and we got started a little late. So if there are any other questions, and Madam JFK, that's how I was introduced to you. Jeanette, excellent advice. I took some notes. Revocable trust, pour over, durable power of attorney, that peace of mind plan, and probate can be up to 110K, you know, and so I took some notes. You talked about LLC. All of those things are things that we need to, you know, meditate on, you know, act on as African people with the real estate and real property. If there are any other questions, I think Jeanette is available for just a couple more questions, and then we're going to conclude the class.
Okay.
Well, one thing that I run into as what's asking about the durable power of attorney, because now I think the issue greater than death is people with dementia and Alzheimer's.
Yes.
Because they don't know when they can no longer control their finances.
Exactly.
And in my family, I have someone who I did get her to sign a power of attorney, but physically she's fine, mentally not. And then another situation where my brother was a co-trustee and he may or may not be okay, and he is given his responsibility to his daughter. So, you know, keeping up with what you've decided and keeping up with the people's mental facility is also important.
Yes,
When you're updating your plans.
Yes, I'm so very glad that you brought that up. So this is why you don't want to wait, because what happens is that those illnesses, they don't give you warning. The onset can be very rapid. And so you don't know. The whole point of doing it and having peace of mind is that you can't gauge when you're going to actually need the document. You want it in place before you need it, because here's a problem dealing with people with incapacity issues. If your capacity, and there are various levels of capacity, you still have the right to have an estate plan. But if you are not of sound mind, as they will have you state in the document, or especially if you've been diagnosed with dementia or Alzheimer's, well, then your whole level of capacity on the document is called into question. And so I've had a case where the person was, had moved to hospice and were starting to show dementia, but her dementia was not that she didn't know who her children were. She knew who her children were, and she knew that she wanted to have this estate plan completed. In fact, she already had one. She had tried to do it herself and was guiding her family along all the years prior to even trying to set the trust up or the estate plan up officially. But what happened, and all the family was in agreement, so there was no issues between any of the siblings. They were all okay to sell the property, but because she signed those documents, and I've done a lot of emergency estate plans, I like not to do those because it's just, you want to have the time to really handle the documents, but in some instances it becomes urgent where someone's health has just taken a downturn. But it was difficult to sell the property because the title companies who insure title took issue with the fact that she signed the documents while she was in hospice, and that one of her medical conditions was dementia. So, that in essence, they could be liable if someone said, well, no, this shouldn't have happened. She wasn't aware of what it was that she was signing. So that could invalidate your document and the authority that's been given. The other thing is you don't want to rely on the trust, because guess what? The trust is only valid during the person's lifetime. Not trust, the durable power of attorney for finances. So that's valid during the person's lifetime. When they pass, it has no value. So your authority ends there. So that's where the trust provides you continuity. So, we think that we have a lot of time, but I used to start these workshops and talk about the people who were young that died. So you all are familiar with Eddie Levert and the OJs, yes?
Yeah.
So at one point, his two younger sons both died, one at 40, one at 39. Would have never imagined that. In fact, the reason I started to learn about probate sales is when I came back to San Francisco, I was looking for a place to live. And, that's when you're being overbid for properties. And I was in one area and I noticed the same agent represented maybe 6 or 7 houses. And I thought, how did this come to be? And she said that she was selling the house for the estate of a young real estate investor. I think he was 33. He had minor children. He was buying properties and fixing them and flipping them, and it was working right for him, but he did not have an estate plan in place. He got into a motorcycle accident. And so there, all of his assets, all of what he was trying to build for his children, his family, were now, going to go through probate court. And he just didn't have the infrastructure set up for what would happen in the event that he couldn't, you can't foresee an accident. But I just tell people that because you're not, tomorrow's not promised to us. And so we want to live our lives fully today. And we don't want to have worries about what's going to happen. So the best way to not have a worry is to just put in place what you want to have happen. And if you change your mind, then, you can change those documents.
So what do you look for in a person to do that? Unfortunately, I don't live in California anymore, so you can't do that for me. But what am I looking for when I want a person?
Well, what state are you in?
I'm in Indiana.
Indiana. Okay. So all the laws will change according to the state.
Right.
I would say for me, people get a feel for you. I would say what I would look for, and this is just informed by my own practice. I used to do housing counseling. So I did the first-time homebuyer workshops. It was exciting for me to help people figure out how they're going to bridge the gap between what they earned and what this house cost by utilizing all these different financial resources that were available, and just how you might stretch and build wealth, basically. So I like that. So I would say it's become less the case now where attorneys just kind of wait for people to walk through the front door. Nobody would have walked through my front door when I started practicing because they, didn't know why they needed it, or it was just an expense. So I went out to the people to say, no, this is why you want to have this in place so that you can decide this, and this. You can avoid this cost. You can eliminate this tax. You can take advantage of this particular benefit. So I would say, look at how the people treat you, and look at people who volunteer to provide information. That's usually a good way to get a feel for people. So go to workshops. So a lot of times I've seen a lot advertised now, especially since we're on we're under COVID restrictions. So a lot of things we had to do in person, now they're being done by webinars. So I think that's wonderful, because now people are reaching out and trying to educate people about the benefit of having, estate plans, or for having a particular service. And so people who do that, that speaks to, I'll say, how they may handle their clientele. So what I would just discourage you from doing, I find a lot of people, they feel like they have the best legal advice when they understand nothing. And I don't, as an educator, before I was able to practice law, I feel like it's dangerous not to understand things, and that, everybody can learn, and that the job or the role of your legal professional is to understand what your wishes and desires are, and to provide a legal framework to have that happen. So a lot of times people ask me, well, can I do this? Can I do that? And I have to redirect and say, what is it that you would like to do? I will figure out how you can do that legally, or, say where things could be altered a bit, but that it's you. So I want you to feel empowered. I want you to feel not that you're being sold, a set of services that may not meet your particular needs. So I want you to look for people who listen to you, and people that have time to respond to you. So if there's an opportunity where you are, if there's a lawyer referral service, we have that here with the San Francisco Bar. You pay $35 for a consultation with an attorney. in an area of law that you need help with. And then that gives you a feel for that attorney. You get to meet with them. You get to see how they've analyzed your case or your matter. And then you can talk about what fees are. And then that will at least give you a personable transaction upon which to employ them. The other thing is referrals. So if there are people that you know and find that you have common ground with, or that if they ask if your friends or family can recommend an attorney, and ask why they like that person, because sometimes people just take you for granted. You look them up, and you come to their office, and I feel like people don't interact enough. The same thing that we do with doctors when we don't ask questions, because I don't know, we've just been conditioned to not do that as much as we should. So I want you to treat your attorney like you would your doctor that has your life in their hands, and you want to ask those questions that are important to you. So you should feel respected.
Okay. Thank you.
Thank you. Wow, what a session. What a wealth of information. Yeah.
Thank you.
Yeah. So, Madam JFK, Jeanette, attorney specializing in generational wealth in the African American community, you've really opened our eyes and on some things. Actually, it was sort of a scared straight session, and so I'm glad. I'm thankful for the questions that were asked. Somebody's should be muted. Okay, yeah. So I'm thankful for the questions that were asked. Really good questions.
Yes.
And so Darnisha is going to put your information in the chat, or get the information, your information to us, because I have a feeling, I'm not a mystic or anything, but I have a feeling that people are going to want to talk to you. They want to reach out and get their estate planned right. Get on a firm footing and use that peace of mind plan. I know I do. So thank you so much for that, and thank you, Mama Darnisha, for recommending her. Next time, next week on the 23rd, Brother Amin Ali is going to be talking about Bitcoins. I've been hearing about Bitcoins, and I want to know about it. It just seemed like, something that's cyber that's into the ether. But let's come at it with an open mind next week. Hopefully you'll be able to join us next week. And then following that, on the 30th, Minister Amadi is going to explain to us who the Neteru are. And so that's the next couple of weeks.